My name is Kay Sieverding. This is an affidavit under penalty of perjury. I was illegally imprisoned by the U.S. government on 3 different occasions, totaling 5 months. I don't have a criminal record at all anywhere. I was never accused of disrupting a courtroom or trial. I'm a graduate of MIT, and I was self-employed for 30 years. The first time I was imprisoned was following a federal court hearing conducted by former federal judge Edward Naughty Nottingham. Naughty Nottingham is his nickname. He was the judge who later resigned after the 10th Circuit reported allegations that Nottingham was calling prostitutes from his court-issued cell phone, and that he asked a prostitute that he regularly hired to lie about their relationship to investigators. 3 days after the first time Nottingham ordered me imprisoned, he was so drunk at a strip club that he couldn't remember how he spent $3,000. Before Judge Nottingham ordered me imprisoned, I filed a lawsuit against officials of the city of Steamboat Springs, Colorado. I alleged that a convicted felon who was president of their city council illegally used city powers to harass me in order to benefit his property at the expense of my property. The felon, Kevin Michael Bennett, criminally blockaded the street adjoining my home and converted it to his private use. Then he used city powers to extort me to give up my right to the street and to sell him land for $1. Then he built 2 buildings that violated the zoning. When I complained, his wife had me criminally charged without a criminal complaint, a statement of probable cause, or a document signed by an employee of the district attorney. Then they got a court order saying that because they had me criminally charged, I must stay 30 feet from Jane Bennett. The 30 feet went inside my home. She followed me around town, asking to have the police investigate me every time she claimed she was within 30 feet of me. Years later, I got an email from someone claiming that Bennett threatened to shoot his family if he bought part of my property. I sued in federal court over this. Nottingham dismissed my claims, but he didn't write an opinion. There was no trial. He ordered me to pay $100,000, but he didn't say why I should do so. He didn't identify the sanctioned conduct or his statutory authority for his order. There were no Rule 11c6 orders. He ordered me to pay law firms that didn't file Rule 11 motions. I suspect that the reason that he did so is that someone associated with my lawsuit paid for Nottingham's prostitutes. I don't think Judge Nottingham could afford frequent use of prostitutes on his government salary. Nottingham ordered that I should be arrested without a criminal charge in order to prevent me from getting a hearing on the merits from another judge. He ordered that I should be imprisoned on an indefinite basis until I filed motions in other courts that he and the defense counsel dictated to me. He put out what he called a warrant for my arrest for the stated reason that I filed a notice of appeal and that I filed motions in other courts. Actually, the 4th Amendment and the rules of criminal procedure require that a warrant be backed by an oath or affirmation that there is probable cause. But Nottingham and the United States Marshals Service ignored published procedure and the 4th Amendment. Bail hearings are required, but I didn't get a bail hearing either. Courts don't have their own jails. The jails and prisons are run by the Department of Justice, and because DOJ is an agency, it is subject to the Privacy Act. The United States Marshals Service is a component of DOJ. In order to book me into jail, the U.S. Marshals used the nationwide Joint Automated Booking System. Yet, DOJ published in the Federal Register that the categories of individuals covered by the system are, quote, alleged criminal offenders, unquote, and no one else. I was never charged with a federal crime. In order to keep me in jail, the U.S. Marshals used the prisoner tracking system. The Marshals created prisoner tracking system form 129s for me, and on those forms they entered that I was detained for, quote, civil contempt, and no other reason. Yet DOJ published in the Federal Register, quote, the categories of records in the prisoner tracking system are any and all information necessary to complete administrative processes, safekeeping, health care, and disposition of individual federal prisoners who are in custody pending criminal proceedings, together with any law enforcement records generated during such testimony. Sorry, I just made a mistake. During such custody. The first time I sued DOJ, their counsel, David C. Rubicki, wrote that the prisoner tracking system requires only a, quote, judicial proceeding, unquote, not a, quote, criminal proceeding. That misrepresents federal law. I was told in Nottingham's court that because I was accused of civil contempt and not a crime, that I didn't have a right to question the witnesses against me or have witnesses on my own behalf. I'm making the statements above under penalty of perjury under U.S. law. K. Sieverding.